I wanted to talk tonight. There's a lot of things I know you want to talk about, but I wanted to talk about this originalism. You know, we started talking about Trump nominees, and one of the most controversial, they're all controversial. But perhaps the most controversial has to do with the nominee that could be around for the next 50 years, this Neil Gorsuch. Have you been following this? Who's very proud to follow Antonin Scalia's originalist theory of constitutional interpretation. Are you familiar with that originalist theory? Tell me about it.
It's two things. It's one thing is he wants to follow the literal text of the Constitution and also what the founding fathers intended. Problem with that is the founding fathers didn't agree on what they meant and what they wrote. So
they say they want judging to be a politically neutral act. That's the first thing they say. The second thing they say is, as you correctly point out, the judges should, I'm just quoting from Scalia, judges should hold parts of the Constitution to the public meaning they had when they were adopted. So the original Constitution is 1788, the Bill of Rights is 1791, and of course there were a number of amendments over the years. Hold it to the meaning of the people who passed those amendments when they were adopted. So I first wanted to talk about the 14th Amendment. You all have your phones, so would you turn to the 14th Amendment? I mean, I can read it for you, but I want you to see it for yourself. Do you have a phone? Do you have your phone with you? Yeah. So let's read. I want to make sure.
That's the equal protection thing, right?
Yeah, I want you all to see it for yourself and make sure that I'm not paraphrasing incorrectly. Okay, so turn to the 14th Amendment. Let's look at the last paragraph. Look up when you have it, so we'll read together. Got it? Here it is. You got it, Didi? Got it? The last paragraph. No state shall deny to any person within its jurisdiction the equal protection of the laws. The 14th Amendment was one of the postbellum amendments passed after the Civil War, 1868. So I want to talk about Jim Crow laws as they applied to public schools, as they applied to public schools. So what was the decision that overturned that? Do you remember?
The Jim Crow laws?
Yeah, Jim Crow laws that segregated public schools. Brown versus Board of Education. Remember the state that was in?
Kansas.
It's interesting. It wasn't Alabama or Mississippi. It was Topeka, Kansas.
That was the Kansas.
1954. Now they used it was a unanimous court, by the way. They used the 14th Amendment, the passage we just read. Voting unanimously, they concluded that racially segregated public schools are unconstitutional. So let's go back to Gorsuch and Scalia's originalist theory of jurisprudence, right? Did the people who wrote this 14th Amendment in 1868 want integrated public schools? What do you say?
No.
What do you say? Is there anybody who thinks that they did? So, but the Supreme Court in 1954 unanimously said that that was unconstitutional. So by the originalist interpretation, they would have had to follow the original Plessy versus Ferguson. You remember that case? 1896, which came up with the infamous policy of separate but equal. Yeah. So this is what the court had to deal with. They studied the public schools of Topeka, Kansas pretty carefully, and they discovered that the teachers in the black and the white schools were paid the same. The facilities were of the same quality. They all had the same varsity and junior varsity sports. All the physical things separating these schools by law in Kansas were equal. So by Plessy versus Ferguson, right, Kansas thought that they were following the 14th Amendment. So the court wanted to know if all of the physical things are equal, why is this a violation of the 14th Amendment? So what would, tell me your name again?
Oh, I'm Stephanie Jeff.
Stephanie, why do you think, how did the court deal with that? If everything physically was equal, why did the court think that it was in violation of the 14th Amendment?
Because everything wasn't equal.
Well, they said, they actually say in the decision that everything was physically equal. They looked at the classrooms, the
It's not
projectors.
economically equal.
Huh?
It wasn't economically equal.
It was, remember, this is in the city of Topeka. They're economically unequal when they're in different jurisdictions, but this is what they said. They said, let's look at the intent of the founders of Jim Crow. They said, why did they separate them in the first place? And the answer they said is clear. The answer they separated blacks and whites in the first place is because they considered blacks to be inferior.
Yeah.
So they said separateness is inherently unequal, despite the fact that they studied all of the physicality of the different schools and found them to be economically equal. But that was the reason they did it in the first place. The quote, the famous quote is, those laws, quote, stamp the black race with a badge of inferiority. So I wanted to look at that issue to discuss originalism. We should judge the 14th Amendment on the basis of what was going on in the minds of the people who wrote it. And all of us know for sure that none of those people wanted black students, although they wanted to do away with slavery. None of those people wanted black students, whether north, south, east, or west, wanted black students to go in the same schools with white students. The way they accomplished that was through housing discrimination. Now, Mrs. Brown's daughter lived across the street from the white school that she was not permitted to go to. I mean, literally across the street. But the way it was what difference between de jure discrimination, which Jim Crow has written into the law, as opposed to practical discrimination, where through housing discrimination you keep people in different schools. So that's what they did in the North, but they used de jure legal discrimination to keep black and white students in separate schools and so. Kansas is one of those border states, you know, that played such an important role during the Civil War. Lincoln was very concerned that that at the beginning of the war, if he was too radical in saying that the war was for slavery, that he'd scare those border states onto the side of the Confederacy. Later on, when it was clear that the North was going to win, they had 3 times the number of soldiers, 3 times the amount of money that they could pour into the war. Then he didn't care whether Kansas and Maryland, you understand, and Missouri would go to the South because it was too late. And then as you remember, we went to did you come with us to the movie, Lincoln? Well, you should see, did you ever see that movie? It's a wonderful movie. And it becomes clear that later on he's finally able to be honest and say that that's what the war primarily, not entirely, but primarily was all about in the first place. So this leads me to the next case, Obergefell versus Hodges, 2015. Does anybody know what that's about? That's gay marriage. And they also based this case on the 14th Amendment. And this was the case with the Supreme Court, this time by a 5-4 vote, voted in favor of gay marriage. And they based it on the 14th Amendment. So let's go around again. Did the people who wrote the 14th Amendment in 1868 want gays to be married?
No.
Well, I mean, so are you beginning to see it? Because it makes no sense. It makes sense to say, in interpreting the Constitution, we should start with
the Constitution
and what they meant by it when it was written in 1868, in 1868, 1788, 1791. But the country has changed. And the meaning, it may, not it does, but it may change. And we have to take those changes into consideration. But originalists like Scalia and Gorsuch don't believe that. naturally, you should start with the original meaning of the passage. So this leads us to the Second Amendment, right? I mean, this is very complicated stuff, obviously. So let's go to the Second Amendment. Get your Second Amendment again. I want to make sure that we're on the same page.
Should've brought my pocket.
Well, you can look on with her.
Oh, yeah.
All right, go ahead and read me it. It's not that long. Yeah, read me the whole thing.
A well-regulated militia being necessary.
Comma. Right, well, it's important because
Okay.
that says it's a separate clause. A well-regulated, comma, go ahead.
Being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed.
Remember, this is the Ninth Amendment, so it's part of the Bill of Rights, 1791. This is probably the most awkward wording in the entire Constitution, but we really do have to go back to 1791 and try to figure out what was going on. We know that there were many different versions of this, and they all were very awkward. And this apparently was the least awkward. You can see that, it has all kinds of twists and turns in it. So let's look at what was going on in the Founding Fathers' mind who wrote the Second Amendment. Now we know, especially in the writings of Madison, who spoke for almost all of them, the Founding Fathers feared standing armies. And I'm quoting from Madison, they believed that standing armies in times of peace, quote, are inconsistent with the principles of republican governments and dangerous to the liberties of a free people. Why? Because throughout history, these standing armies have been used by tyrants to overthrow popularly supported governments through coups. It happens over and over again. They knew you had to have armed forces to protect the nation, both from insurrections internally and also from people attacking us from far. So they resorted to these for the most part, to these well-regulated militias, which is right there, well-regulated militia, comma, be necessary to the security of a free state to protect the nation. Now, when there was a war, these militias would march around on Saturdays, that's how they would practice. But there was no standing army. During wars, there were standing armies. So, for example, the Continental Army, that was a standing army that was set up during the Revolutionary War, but still militias fought as well. You remember some of the famous militias? Remember the one in South Carolina? The guy they called the Desert, the Swamp Rat, Francis Marion. There's been all kinds of movies about him.
They're the Patriot, that's what we're based
That's
on.
it, you got it.
Yeah.
Yeah, you're good. You really know your movies. So, if they relied mostly on these private militias, for example, if you pass by Spring Hill College, you know that Spring Hill College sent the militia from Spring Hill College to fight in the Civil War. How do you like that? The University of Alabama did as well. So in order to march around and learn how to shoot straight, etc., these militiamen had to bring their own rifles. I mean, right? Because it wasn't a professional army. So the governments were not outfitting these guys with arms. That's number one. Number two, who were the Founding Fathers who wrote the Second Amendment most fearful of that would defeat the states and take away the liberties of the people of the states? Was it England, or France, or Spain, or was it the American federal government? It was the American federal government. Understand? So these state militias that were based locally, like for example, Spring Hill College, for the most part, were being protected to protect the states and their reserved rights under the 10th Amendment against the federal government trying to take away those reserved rights. Read the 10th Amendment, you'll see what I'm talking. They made sure to put that. The 10th Amendment is written very carefully. Check out your 10th Amendment. This, they wanted to make sure everybody knew the way they felt. Look up when you get it. It was the federal government they were most afraid of. So they didn't want the federal government taking away the arms of local people who could then use them to protect the states from an abusive, tyrannical federal government. Look up when you get it. Go ahead, read it.
The power is not delegated to the United States.
The power is not delegated to the United States.
By the Constitution, nor prohibited by it to the states, or reserved for the states
There you go.
respectively or to the people.
So there you go. They were very clear about that. Of course, remember, they had lived, the key historical figure they're referring to is George III. But not just George III as a tyrannical English king, but George III as an example of a tyrant. And in their mind, they could see that these tyrants could also pop up in America as well, homegrown tyrants as well. So now you know what the Second Amendment means.